All right, I'm here with David Azizi from the law offices of David Azizi, and something we have discussed quite a bit over the last few months is trip and fall and slip and fall cases. And what is important to understand is that sometimes a trip and fall case can be a little more difficult than other times when the size of the indentation is at a different length. And David will do much more to describe that. So first of all, David, describe a trivial defect and then describe the size at which it really makes a difference.
Okay. Well, in terms of the term trivial defect, the old cases had some rule of thumb which the courts had said anything under an inch is considered to be a trivial defect if there was an offset in the sidewalk. So there was a period of time where everybody was going to court and saying, all right, well, Your Honor, this or the city or whoever owned this particular condition, and say, look, it's less than an inch, it's a trivial defect, throw their case out. And basically what that means is that under the trivial defect doctrine, what that essentially meant is that it's such a trivial effect or dangerous condition, or at least not a condition, it was actually said to be not a, because you've termed it as trivial, it's then considered not to be dangerous, and that it's not anything for it to get to the jury. So a lot of cases were getting thrown out on summary judgment, which is basically a motion that the defense files to get rid of your case before it gets to a jury. But subsequent to that, the courts got another chance to review it and said, look, there's no hard, fast rule that says if anything's below an inch, then that's it. You don't get to recover. You have to do a fact and analysis test and determine that this trivial defect, is it something that the defendant created? Is it something that, excuse me, the defendant had an opportunity to fix? So there's a lot of factors that go into that. A lot of times people say, oh, it's a trivial defect, it was small enough, or you know, this person should have seen it, or it was visible. But if you look at the cases, sometimes you can argue that the sunlight was casting on that area or a shadow of it and made it difficult for you to be able to see that rise in order for you to avoid that trip and fall. So a lot of times I've had clients of mine come in and say, you know, I've been told that I cannot recover because the condition was considered a trivial defect. And that may be true, but in some circumstances I've been successful in helping clients recover rightfully, even on situations where it's a trivial defect, because we're able to argue, for example, this was a condition that the defense knew about it or should have known about it and they could have repaired it. Or the other thing is, situation is that it was created by the defendant, and because it was created by a defendant, the trivial defect issue is no longer an issue because they created this condition that can cause somebody to trip and fall.
Absolutely. So if you have been in a trip and fall or a slip and fall situation in the state of California, please feel free to contact the law offices of David Azizi. You will see the phone number both above and below in the YouTube information. There's also a blog post in the YouTube information that will explain more about this particular situation. Thank you for your time, David.
All right, thank you.